Hi, everyone. I'm Andrea Perez. I'm an art lawyer. I'm with a law firm of Carrington Coleman, Sloman, and Blumenthal. We are a full service law firm representing clients throughout the United States, and we actually have an art law practice that deals with unique legal issues in the arts. In addition, I'm an adjunct lecturer at Southern Methodist University. I teach a class called International Law and the Arts at the Meadow School of the Arts there. So the arts are near and dear to me and a big passion of mine. So I'm so honored to be here today on behalf of the National Association of Women's Artists and cannot thank them enough for this opportunity to speak with you all. Also, thank you to all the members of National Association of Women Artists who are joining us today. So there's many different rules and laws that protect artists, and today I'm just going to focus on some important rules that are for visual artists. There's different laws that help musicians and performers and things like that, but there are some unique things for visual artists that I think you should know about in your career. I'm going to briefly discuss a few important topics, but if you want to know more about things I'm discussing today or have questions that are unique to your circumstances, please feel free to reach out. I've got my contact information here on the first slide, and then I'll put up my contact information on the last slide as well. So now that we've finished an introduction here, let's go ahead and get started. So we're going to begin today with copyrights. Copyright law is the most important law that's going to protect visual artists. And registering a copyright is the most important thing you can do to protect your artwork. So a copyright is what is created when you create a work of art, when you put it in a tangible form, something that people can hear or see. And it's actually created, this property right you have in your artwork is created the moment you finish it. It's automatic and you're entitled to protection for it. I highly recommend that when you're creating your visual art that you somehow display, maybe on the back of the canvas, the back of the work, somehow display the copyright symbol, the notice or the circle C that you see on the slide, with your name and the year that you created the work. So, and then once you've created a work of art, you're actually going to have protection and can prevent others from copying your work, making derivative works, selling your work, licensing, all these different rights that you have for your entire life, plus 70 years. So your heirs can also protect your rights. Now, there is one little important caveat. So if you're working with another artist on a project and you're creating a joint work, the protection will actually last the life of the last surviving artist plus 70 years. So you could be entitled to even more protection as well. So you've created a work of art and now you have this copyright. What legal rights do you have with that? Well, believe it or not, in the US, you cannot file a lawsuit for infringement of your copyright unless you have the work registered. It's a prerequisite. Many artists don't know that, and it's so important. You see someone steal your work, and then all of a sudden it's like, well, what do I do? Well, you could send them a letter, but if it's that bad, and the infringement is that bad, you're probably going to need to sue them, and you can't do that until you go back and register your copyright. So how do you do that? Well, there's a process with the US Copyright Office. Most people file online. It's really easy. The fees range, they're between $45 to $65 for an application for one work, but there's some newer rules that allow you to register works in groups that to try to save you money. Because thinking about, having to register one work for $45 and then however many works you created, that can be just impossible financially. So there's ways to protect groups of works and also sort of deciding what works you'll register or not. There is in this slide here, which will be available, there's a circular from the US government that's really helpful guide on how to fill out a copyright application. And then I've also got a link here on where you go to submit online. The process will take about 3 months. And it's usually they communicate with you via the email address that you provide when you register the work. Now, if you're in a bad situation and you can't wait about 3 months to get the whole process completed, there is a way where you can expedite processing of your copyright application. So let's say you see someone that is infringing your work. and it's very bad situation and you need to likely sue, you can pay, it's a fee of up to about $700 to expedite the processing as well. The Copyright Office also offers some other resources, like they'll do copyright research for you and search the database as well. They typically charge a couple $100 an hour, but they do other things as well to help the copyright registration process. So if you're a photographer, you have the ability to register a group of photographs for just about $55. And I'll go into that more in this presentation. And then if you've got unpublished works, you could do, let's say you've got 10 paintings, 10 sculptures, things like that. You could do a group of 10 in one application to try and save fees. So one thing that's important to note is whether the work has been published or not. This is some information you're going to give in the copyright application. And it's a little bit confusing on what it means to have a work published, but the U.S. Copyright Office is trying to work on this and give some better guidance. So as of now, how they describe when a work is published, that means an artwork has been published on a specific month, day, and year, that a copy or multiple copies of that work were distributed to the public for the first time. So when you think of this description of what published means in relation to the internet and online posting, it gets a little confusing. So my best advice that is, if you're going to be selling your work online, and if you're going to, so either post, prints for sale or your artwork online through Instagram, through your own website as well, you're likely publishing it. And so that's something that you'll note in the application when it sort of becomes available to the public. But then also I suggest that the best practice is, before you're going to put a work online for sale, start the copyright registration. Let's say for an exhibition, you have, maybe 15 works that are coming up that are going to be exhibited. And it would probably be, I would suggest, go ahead and starting the copyright registration application prior to that exhibition occurring as well. And so the information in a copyright application to register is really straightforward. And you fill this out all online, you create an account, and you're going to include your name, or if there's multiple authors of the work, both names or 3 names. You're going to note whether you have to note whether it's a work for hire. And that's a really important term, and I'm going to discuss what that means today. You're also going to note your birth date, or if the author has passed away, the date of death, the title of the work, the year the work was created, whether it was published or unpublished. Then description of the art. Is it a sculpture? Is it a 2D work? Different types of visual art. They have descriptions in the application. Kind of just select which one. And then you list who the copyright claimant or owner is, because sometimes, so the copyright claimant is the one that actually ends up with the rights to the copyright. And we'll talk about how you can transfer a copyright here today. But it could likely just be you if you've never given the copyrights to someone else, or it could be someone else if you have. Now, I do want to stress that creating a work of art creates a copyright, but simply owning a work of art does not always transfer the copyright. So if you are commissioned to create a painting for a collector, you will own the copyright to that. Yes, physical possession of that artwork will go to the collector, but if that work needs to be displayed, or they want to use it commercially for some reason, copy it, make prints, your collector cannot do that without your permission. You still retain the copyright and the legal rights to those things. And we'll discuss, like I said, if that's transferred. So, and then what else? There's a deposit of the work. That's usually you just send in the application, you upload images of the artwork, and then you put information like the contact information, your address, your email and phone number. So when the Copyright Office needs to talk with you, they know how to reach you and get permission for requests for licensing and things like that. So there's a newer way to register copyrights for photographs that I want to make sure you're aware of. If you're a photographer, you can register up to 750 photographs in one application. And so that's really beneficial on a cost savings perspective for you. So there's some little caveats here. Either all works have to be unpublished or published. You can't have a mixture. They all have to be the same author, and you have to be the same author and same owner as well. And then you have to provide dates on when they were published, the first date they were published, or maybe the latest date that they were published as well. So that's a really cost-saving tool for photographers in protecting their copyrights. Then if for a group registration, this is not photographs, but if you have a series of unpublished works, so this would be sort of ideal in a situation where you're about to be exhibited, maybe by gallery, or post a series of work online. You would fill out one of these applications as well, and it requires you to provide a separate title for each work. It all has to be made the same type, so either all paintings or maybe all sculptures, right? And then it has to be the same author as well. And you'll have to provide electronic images and name those files so they match the title of the artwork, so that when the Copyright Office looks at the files, they can easily see where they belong. Why I'm telling you to register your copyright is because of damages and how important this is. Well, first, you can't sue if you haven't done that, right? But second is, if you register the work prior to the infringement occurring, you could have a lot better legal standing and maybe recover a lot more financially from the situation. So if the registration of a work occurs after the infringement happens, you can only recover what is called actual damages and lost profits. And this is something that you have to prove. It may be very difficult to find out how much money someone has made off your work. Also, it may be difficult to even see if there's any actual damages if they did not sell anything or make any money off of it. So maybe your photograph appears on a blog for someone, but they're not really making any money off of it. What are your actual damages? It could be very little. And so pursuing that claim wouldn't make sense. However, if you did have the work registered, either within 3 months of your publication of the work or before the infringement starts, you sort of have two options there. You can ask for what's called statutory damages and receive attorney's fees. So statutory damages are fines imposed on the actual infringement, and they could result in more financial recovery for you. You can receive up from $750 to $30,000 for each work that was infringed, even up to $150,000 if work was willfully infringed. And if it was an innocent infringement situation, though, which is not that easy to prove, but at least $200 per work. And then you can recover attorney's fees as well in going after the infringer. So this is really something that is important and could really help not only in your legal fees, but also help in attorneys maybe wanting to take the case on a contingency basis, which means they're not going to charge you any fees up front, and they will only recover their fees if they're able to recover from the lawsuit on your behalf as well, too. So it's a really important tool here. So definitely register your copyrights and try to register them as soon as possible so you get these benefits. So the next topic here is moral rights. So when we're talking about with copyright infringement, we're usually dealing with economic rights, and that is your right to copy, sell, distribute, make derivative works, make money off the artwork. But there's a unique provision in a law from 1990 called the Visual Arts Rights Act that gives moral rights to only visual artists at this time. It likely will be expanded, but this is unique to you. And what it does is you get a right of integrity and a right of attribution. So the right of integrity means you can prevent someone from destroying or altering your work and mutilating your work or damaging it and recover damages from that. You have a right to keep your work intact as you've created it. The right of attribution means that no one can take credit for your work. If it is yours, You cannot, they cannot say it's theirs or, fail to give you credit. Also, it gives you the reverse right of saying, I'm no longer going to take credit for the artwork and disavowing artwork. Artist Katie Nolan is sort of notorious for this and has had a few legal cases where she has decided that she is no longer the artist of her own work due to some damage or some way the artwork was handled. And so she can disavow the work. That's a right that you have as well, too. So moral rights are really important because it opens up your ability to recover damages and sue for copyright infringement as well. It's another type of lawsuit that you can bring in addition to someone stealing your artwork as well. And it's important that you can't just give up these rights easily. You have to sign a written document, a contract that says, I'm giving up my moral rights in order to lose those. So how this would most likely come about is if you were either creating something commercially or maybe a commission for collector, and they have you sign a document that says you're giving up your moral rights. You cannot also transfer these. These stay with the original artist at all time. The only thing you can do is maybe give up the rights, like I said, via a written agreement you have to sign. Briefly, there's a really important case involving 5 Points in Brooklyn that sort of really brought to light how important moral rights are recently. And it involved a piece of land, property out in Brooklyn that was known sort of as a museum and sort of a haven and a gallery for street artists, graffiti artists. And I believe there was over like 15 different artists were featured in and had works, and it was well curated. The building owner, made sure that there was sort of dedicated spots for artists of certain stature. Well, the building owner sold the property for a new residential development and did not consult with the artist on what was going to happen with the artwork, and did not give them a chance to take their artwork, which that is something that you have a right as a moral, in these moral rights and in VARA, in that statute, you have to be given an opportunity to reclaim your work if it's going to be destroyed. And the developer didn't do that and then just whitewashed the whole building. The developer lost on moral rights and had to pay over $6.7 million to several artists for violating their moral rights and destroying their artwork and not giving them a chance to reclaim their artwork. So moral rights is really important, and it's something that you can use in addition if you haven't been credited properly as a way of seeking monetary relief for that too. So the next topic is work for hire rules. And this is a little bit complicated, but again, the rules are actually on the side of the visual artist here. So there's two situations. So you could be creating artwork in the scope of your employment as an employee, or you could be a freelancer contractor. So the first concept to understand what work for hire is a little bit simpler. And that deals, if you are a true employee and you are a W-2 employee, your employer pays your taxes, employment taxes, you are, the artwork you create in the scope of your employment, now it has to, not outside of that, but the artwork you create and copyrights you create inside that scope of your employment and your duties will automatically be owned by your employer. They are the author of that. Okay, you lose that, lose those artworks. But if you are an independent contractor, it's the reverse, and there's rules to protect you. So if you are sort of commissioned for work, or you're doing contracting consulting work, and you are a contractor on your own, you're not a full-time employee or an employee under employment laws, you keep your copyrights, and sort of you're just giving a license to the party that's commissioned you or hired you for this project to use that. You actually own the copyrights for that, and could prevent certain uses by that party that commissioned you or hired you in the future. The only way that the copyrights are going to be transferred to the person that commissioned you or hired you is a pretty tough test to pass. So first, they have to prove that you were commissioned for the project or hired for that project, right? And then you have to fall into this list of what they commissioned you for. Okay, so and the list on the slide here includes contribution to collective work. So that's like a periodical or encyclopedia, part of a motion picture, translation, supplementary works, which could include illustrations, forewords, things that supplement literary works, compilations. So this could be newspapers, websites, also maybe creating a book or catalog of photographs and artwork, instructional texts, answers, test materials, things like that, in an atlas. So the list is old and likely outdated, but so that's step 2. Did you create one of these things? And then step 3, was there a specific written document saying that this was a work made for hire? And there's a part in the copyright laws that describe what a work for hire is and have these rules, but is it a work for hire? So only if you get yes on all 3 of these, would the copyrights transfer to the party that commissioned or hired you. You keep those rights to make derivative works in copies and ability to distribute them as well. And so this could cause some rub because there could be a misunderstanding with the person that hired you, thinking they have full rights to that, and they don't. They likely have a license of some sort to based on what the terms of the project were, but you really need to nail down and figure out what license and rights they have to the artwork you created as part of that project. Also, a way around this is that instead, in the agreement that you signed for the project, there could be language that says, if it's not deemed a work made for hire, you still are agreeing to transfer over the copyrights. And if that's the case, then you've made a copyright transfer anyway. It's sort of kind of a catch-all way of making sure that the party who commissioned or hired you gets the copyrights. So, and it's interesting to note that if you, when you create a work made for hire, if it's deemed that, you're not the author anymore. The person that commissioned and hired you is going to be seen as the author of that work. So the final topic I want to discuss is actually terminating copyright transfers, which is a pretty powerful right. And we're seeing this used more and more often, actually in the case of music. You can still use this for visual art as well. So there's a set of laws and timelines that apply to works that copyrights that were transferred after 1978 and ones that were before. I'm only going to discuss after 1978, but there is still ability right now to recoup back and get back your copyrights that you may have assigned prior to 1978. So you can terminate these, the ownership of the copyright that someone got. Now, keep in mind, it's not ownership of the physical artwork itself, that if you've given to a collector, they own and can sell and so on and so forth. But we're talking about the rights that are within the artwork, the ability to copy and make derivative works off that artwork. So, and use it commercially as well. So after the copyright has been transferred, if 35 years have passed, you can seek out to get this back and recapture your copyrights. So there's sort of a 5-year period that runs. So you transferred, let's say you transferred it in 2000. At 2035, there's going to be a 5-year period that starts where you can recoup back your copyrights. So if it's been published, there's a little bit of a different rule. That starts running either 35 years after the date of publication or 40 years after the date of the copyright transfer. Terminating copyright transfers, though, do not apply if the original work was created and transferred as a work made for hire. So again, this is only if, only if the work for hire situation is not applicable to you, can you use this. But also, if you transfer it via a will, let's say you've passed away and you've left it to someone, this law is not applicable in those situations either. And you cannot contract around these rights. So someone cannot make you sign a piece of paper saying you're giving up these rights. You're entitled to always have this. And the reason being is the Copyright Office felt that, look, if someone is commercially making money off of your work for 35 years, they've had a lot of time to make money off your work, and it's time to give you back your rights. So again, this is why we're seeing so many musicians that are using this, and some very big name musicians have been able to get back their music rights. Like again, I said it's for visual artists can use this as well. So it requires a very specific type of notice to be sent to the person that you transferred the copyright to. And I don't suggest doing this on your own. There are templates. The Copyright Office offers different publications too on how to fill out, but it's very specific information you have to provide in the notice. You could likely get a template, but I would at least ask a lawyer to look at it, or seek out certain pro bono organizations for artists that provide legal services. There's definitely several in New York, all throughout the US as well, and they can help you with that too. And you have to serve the notice by personal service or first-class mail to the individual that is now owning your copyrights. And you can serve that either no later than 2 years before that termination date ends. So when that end of that 5 period ends, you have up to 2 years before that 5-year period ends to send the notice. And then, or 10 years before that 35-year mark starts. So you have a long time to send the notice in and let them know the copyrights are going to be terminated and they're going to go back to me, right? But what's really important is that you have to record your copyright termination notice with the Copyright Office too. So that is another step you have to take. So this is an incredibly powerful tool to get back your artwork that you may not have known about. And if it's something that's very successful and is licensed frequently and does quite well commercially for you, you could really recoup back a lot of money off of your artwork. So with that being said, those are all my topics I have for today. I know I've went briefly through these very important topics, but if you have any other questions, please feel free to reach out to me. I'm always happy to talk with artists and help out as much as possible. I'm also on the board for Texas Accountants and Lawyers for the Arts here in Texas, which is a pro bono organization that provides free legal advice to artists and arts-related nonprofits. Like I said, there are very similar sister organizations throughout the US, wherever you're located as well. So I hope this information was helpful. Again, reach out if you have further questions. And I cannot thank you enough for joining me today. And also cannot thank the National Association of Women Artists for letting me speak with you today. So thanks so much. Bye-bye.